दोस्तों ये डिक्टेशन दिल्ली हाई कोर्ट के पीए एसपीए के लिए है। दिल्ली हाई कोर्ट में पंक्चुएशन मार्क्स नहीं बोले जाते हैं, मतलब कामा फुल स्टॉप ये सब नहीं बोले जाते हैं, इसलिए इस डिक्टेशन में मैं पंक्चुएशन मार्क्स भी नहीं बोल रहा हूँ। सिंपल डिक्टेशन होगी। 100 से 110 वर्ड पर मिनट के आसपास रखने की कोशिश करेंगे, जिससे कि पीए और एसपीए दोनों के लिए आप डिक्टेशन लिख सकें। चलिए स्टार्ट करते हैं। बी रेडी, स्टार्ट। मिस्टर दिवाकर सुबोध, learned counsel for the appellant, would argue that wide exhibit Kha, the plaintiffs received a sum of rupees 4,000 from the defendants and handed over the vacant possession of the land covered by Khasra number 439, and with such handing over the plaintiffs relinquished their right, title and interest with respect thereto. This being the position, although the deed was not a registered one, the learned trial court ought to have held that the plaintiffs ceased to have been titled to the suit land. Having noticed the aforesaid ingredients of substantial question of law, it naturally falls for consideration as to whether these premises, both factual and legal, do really exist. The pleaded case of the plaintiffs is that without there being any transfer of title, the defendants entered into the suit land by deceitful means. First, they got their names illegally mutated in the records of rights on 7/7/1992, and thereafter by applying force ousted the plaintiffs from the suit land. In the plaint, the defendants have been described as trespassers, and there was no prayer for adjudging Exhibit Kha sale deed as illegal. The learned trial court observed that as per the version of the plaintiff's witnesses, the defendants forced their entry into the suit land, and that they did not have any right of adverse possession as well. With these findings, the learned trial court held that the defendants are mere trespasser over the land, and the plaintiff's right over the land continued. The learned trial court took note of the fact that the sale deed in question was unregistered one, and on the face of the aforesaid observation of the learned court below, the first substratum of the sole question of law as the execution of the sale deed appears to be non-existent, while the second factual substratum is about payment of consideration. The same automatically becomes volatile when the learned courts below arrived at findings that the defendants dispossessed the plaintiffs and there was no execution of sale deed. Even keeping the first factual aspects aside for the time being, the third element, construing substantial question of law, assumes importance. It can be the legal effect of an unregistered sale deed is discernible from perusal of section 47 and 49 of the Indian Registration Act. Section 49 deals with consequence of non-registration of the sale deed, which is compulsorily registrable under Section 17 of the Indian Registration Act. It is thus clear that a sale deed which is required by Section 17 of the Registration Act as well as Section 54 of the Transfer of Property Act to be registered and is not registered, it shall not affect immovable property comprised therein, and so no title would be conferred thereby. By proviso to the said section, use of such document for collateral purpose only has been recognized. I have perused the grounds enumerated in Memorandum of Appeal and did not come across any objection in regard to perversity of finding of the learned courts. दोस्तों, ये डिक्टेशन आपको कैसी लगी कमेंट में ज़रूर बताइए, और अगर अच्छी लगे, डिक्टेशन आपको हेल्पफुल लगती है, तो इस वीडियो को लाइक कीजिए और चैनल को सब्सक्राइब कीजिए। थैंक यू।